This is Proximate Cause from Group 2 of TORTS 2022. We've heard about proximate cause from crim law, but how do we define it? To know a little bit about proximate cause, let's watch this.
For a cause to be seen as the proximate cause of a loss, it must be the dominant cause, and there must be a direct link between it and the resulting loss. You can imagine this as a row of dominoes. If the first domino is toppled and it knocks all the others over in turn, the first domino can be seen as the proximate cause and the last as the resulting loss. If, however, a domino from the centre of the row is pushed first, the first domino can no longer be seen as the proximate cause, as it is no longer responsible for the resulting.
A proximate cause is such adequate and efficient cause as in the natural order of events, and under the particular circumstances surrounding the case would necessarily produce the event. It is one which is natural in sequence, undisturbed by any independent cause, produces the result complained thereof. And the result, however, must be the natural, probable consequence, such as ought to have been foreseen as likely to flow from the act complained of. This was in Bowyer's Law Dictionary. Now, in the case of Abulgar versus Cosmos Bottling Company, in Intergames Incorporated, proximate cause was defined as that which in natural and continuous sequence, unbroken by any efficient intervening cause, produces injury, and without which the result would not have occurred, which were foreseen or could have been foreseen because they were in the natural order of things. Again, Maki versus Intermediate Appellate Court has this proximate cause definition, which is that cause which in natural and continuous sequence, unbroken by any efficient intervening cause, produces the injury, and without which the result would not have occurred. So more comprehensively, the proximate legal cause is that acting first and producing the injury, either immediately or by setting other events in motion, all constituting a natural and continuous flow and chain of events, and each of those having a close causal connection with its immediate predecessor. The final event in this whole chain immediately affects the injury as a natural and probable cause, or result of the cause which first acted, under which circumstances the person responsible for the first event should, as an ordinary prudent and intelligent person, have reasonable ground to expect at the moment of his act or default that an injury to some person might probably result therefrom. Now, who has the burden of proof? The burden of proving the negligence that is the proximate cause of the quasi-delict is on the one alleging the same. The person who alleged negligence must prove it. This is in the case of Sea versus Villanueva. And the burden at first instance, as in the case of PLDT versus Court of Appeals, states that a person claiming damages for the negligence of another has the burden of proving the existence of such fault or negligence causative thereof. The facts constitutive of negligence must be affirmatively established by competent evidence. Whosoever relies on negligence for his cause of action has the burden in the first instance of proving the existence of the same if contested. Otherwise, his action must fail. Now, Article 2179 of the new Civil Code states when the plaintiff's own negligence was the immediate and proximate cause of his injury, he cannot recover damages. Our jurisprudence on Abulgar versus Cosmos Bottling Company and Intergames Incorporated. For the facts of the case, a claim for damages arising from the negligence causing the death of a participant in an organized marathon bumped by a passenger jeepney on the road of the race. the safeguards allegedly instituted by the Intergames in conducting the marathon had fallen short of the yardstick to satisfy the requirements of due diligence as called for by and appropriate under the circumstances. Now, this accident happened because of an inadequate preparation and the Intergames' failure to exercise due negligence. The respondents could not have an excuse from liability by hiding behind the waiver executed by Rommel and the permission given to him by his parents because the waiver could only be effective for risks inherent in the marathon. As to the issue, we ask whether or not the organizer and sponsor of the marathon were guilty of negligence, and if so, was their negligence the approximate cause of the death of the participant? The court ruled, yes, negligence is a failure to observe for the protection of the interests of another person, and that degree of care, precaution, and vigilance which the circumstances justly demanded, whereby such other person suffers injury. Under Article 1173 of the Civil Code, it consists of the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the person, of the time, and of the place. The Civil Code makes liability for negligence clear under Article 2176 and Article 20. In Article 2202, in crimes and quasi-delicts, the defendant shall be liable for all damages which are the natural and probable consequences of the act or omission complained of. It is not necessary that such damages have been foreseen or could have reasonably been foreseen by the defendant. Now let's go to our bar question on quasi-tort and proximate cause. On the 2010 bar question, it asks, define quasi-tort and who are the persons liable under quasi-torts and what are the defenses available to them. The suggested answer is that quasi-tort is considered as the equivalent of quasi-delict. Hence, the rules of the latter pertaining to persons who can be held liable and their defenses would also apply. Those liable for quasi-delict include, number 1, the tortfeasor or the person causing the damage to another through fault or negligence, as stated in Article 2176 of the New Civil Code. And number 2, the persons vicariously liable under Article 2180 of the New Civil Code. These are the defenses available. Number 1, that the defendant was not negligent or that he exercised due diligence based on Article 2176 of the New Civil Code. Number 2, that although the defendant is negligent, his negligence is not the proximate cause of the injury, as in Article 2179. Number 3, that the plaintiff's own negligence was the immediate and proximate cause of his injury, as in Article 2179. Also, number 4, that the person vicariously liable has observed all the diligence of a good father of a family to prevent damage, as stipulated in Article 2180. Number 5, that the cause of action has prescribed after the lapse of 4 years, as in Article 1146 of the New Civil Code. And number 6, the fact that the plaintiff had committed contributory negligence is a partial defense, based on Article 217 of the New Civil Code. Now, what is cause in fact? You might ask, what really is cause in fact, as opposed to proximate cause? When proximate cause relates to the relationship between the event and an injury in the context of the law, there must be a sufficient relationship between an event or an act and the resulting injury in order to prove legal responsibility, or what we call liability. Now, this concept is called causation. And there are two types of causation. First, that is the cause in fact causation, and the second is the proximate cause, which we discussed earlier. Now, cause in fact is actually the actual cause, or vice versa. This is very straightforward. When a bus strikes a car, and the bus driver's actions are the actual cause, or the cause in fact of the accident. Cause in fact causation can be best described as a but-for chain reaction. But for the action, the injury would not have occurred. So for example, Lisa turning left at the red light, the car crash would not have happened. Now, while the cause in fact causation is relatively a very straightforward concept, proximate cause is harder to define, though we've already defined it previously in my slides. If someone though suffers injury and that they believe that injury was caused by another person's actions, the injured party or the plaintiff may want to sue the actor or the defendant for damages like medical bills or lost wages. But in order for this to prevail in court, the plaintiff must prove that the defendant is liable for his injuries. The same concept applies in criminal prosecution. That is, the government must prove that the defendant caused the victim's injury or death. This is where proximate cause comes into play. Now, simply put it, actual cause or cause in fact is equivalent to the plaintiff's injury would not have occurred without the defendant's act. That means straightforwardly, the act causes the injury or damage to the plaintiff. However, in proximate cause, the plaintiff's injury was directly caused by the defendant's act and was a reasonably foreseeable result of the defendant's act. So it could have been foreseeable or it could have been prevented, but it was still brought about by the defendant's act. Now let's go to another jurisprudence, mainly on proximate cause, People versus Villacorta. The facts of the case state that while Cruz was ordering bread at Mendeja's store, Villacorta suddenly appeared and stabbed Cruz on the left side of his body using a sharpened bamboo stick. The bamboo stick broke and it was left in Cruz's body. Immediately after the stabbing incident, Villacorta fled. In this case, the RTC rendered a decision finding Villacorta guilty of murder, qualified by treachery, and the Court of Appeals promulgated its decision affirming in toto the RTC judgment of conviction against Villacorta. Now, the issue of this case was whether or not there was an efficient intervening cause from the time Javier was wounded until his death, which would exculpate Urbano from any liability for Javier's death. The Supreme Court ruled that the proximate cause of Cruz's death is the tetanus infection and not the stab wound. In the event he is found to have indeed stabbed Cruz, he should only be held liable for slight physical injuries for the stab wound he inflicted upon Cruz. If Cruz acquired several tetanus infections from the stabbing, then the symptoms would have appeared a lot sooner than 22 days later. Ultimately, we can only deduce that Cruz's stab wound was merely the remote cause, and its subsequent infection with tetanus might have been the proximate cause of Cruz's death. The infection of Cruz's stab wound by tetanus was an efficient intervening time. Cruz was stabbed to the time of his death. The Supreme Court further ruled that the infection of the wound by tetanus was an efficient intervening cause later or between the time Javier was wounded to the time of his death, and not the proximate cause. The infection was therefore distinct and foreign to the crime. Thank you for listening and watching. Let's proceed now to the next topic on efficient intervening cause.
Good evening, everyone. Now let's distinguish cause from condition. One of the elements of negligence is cause. There are two types of negligent cause: actual cause and proximate cause. Actual cause is sometimes referred to as cause in fact. The plaintiff's injury would not have occurred without the defendant's act. The second type of negligent cause is proximate cause. Proximate cause requires the natural, direct, and uninterrupted consequence of a negligent act or omission to be the cause of a plaintiff's injury. The plaintiff's injury was directly caused by the defendant's act and was a reasonably foreseeable result of the defendant's act. Now let's proceed to condition. Condition are the circumstances affecting the way in which people live or work, especially with regard to their safety or well-being. The Supreme Court adopted the view that it is no longer practicable to distinguish between cause and condition. The Supreme Court adopted Foster and Kitten's view about cause and condition. When the conflict arises because the one person, either through carelessness or unintentional action, causes injury or loss to another, without necessarily doing something technically illegal, this society revolves a dispute with tort lawsuits. Cause and condition are occasionally mentioned in the decisions, but the distinction is now almost entirely discredited, so far as it has any validity at all. It must refer to the type of case where the force is set in operation, but the defendant have come to rest in a position of apparent safety, and some new force intervenes. But even in such cases, it is not the distinction between cause and condition which is important, but the nature of the risk and the character of the intervening cause. All persons are obligated to be careful in all our actuations. The basic principles to be observed for the rightful relationship between human beings and the stability of social order are found in Articles 19 to 36 of the new Civil Code. Now, let us discuss the first three provisions of human relations as stated in the Civil Code. Article 19. Every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. This is a general rule which governs the conduct of human relations. By itself, it is not the basis of an actionable tort, but it describes the degree of care required so that an actionable tort may arise when coupled with Article 20 or 21. Article 20. Every person who, contrary to law, willfully or negligently causes damage to another shall indemnify the latter for the same. Concerns violations of existing law as basis for an injury. It allows recovery should the act have been willful or negligent. Article 21. Any person who willfully causes loss or injury to another in a manner that is contrary to morals, good customs, or public policy shall compensate the latter for the damage. In Article 19 and 21, the act must be intentional, but in Article 20, it need not be intentional. Now let me present to you the case of Religiosa versus Religiosos in relation to Article 19 of the Civil Code, which requires that every person to act with justice, to give everyone his due, and to observe honesty and good faith. GR number 138964, dated August 9, 2001. The case of Reliosa versus Pilioses. This case seeks to reverse the CA in countenancing an attempt to abridge and render inutile a legal right to contest an adverse ruling of an agency of government. Now let's proceed to the facts of the case. Respondents were lessees of a parcel of land owned by Marta Reyes, located at San Pascual Street, Malate, Manila. Unfortunately, Marta Reyes died. After Marta died, Victor Reyes, her son, inherited the land. Victor informed the respondents that they would have a right of first refusal to buy the land. But in 1989, without the knowledge of respondents, the land was sold to petitioner Cynthia Ortega, who was able to ultimately secure title to the property in her name. Cynthia Ortega filed petition for condemnation of the structures on the land. The Office of Building Official issued a resolution ordering the demolition of the houses of the respondents. Copies were received by respondents on December 7, 1989 and on December 12. The day respondents filed an appeal contesting the order. Petitioners proceeded with the demolition of the house. Respondents filed a case before Manila RTC but was dismissed. On appeal, CA reversed the decision and ordered petitioners to pay respondents for moral and exemplary damages as well as attorney's fees. Now, what is the issue raised in this case? Whether or not the CA gravely erred in ruling that the premature demolition of respondents' houses entitled them to the award of damages. The court ruled as no. Now, what is the rationale behind the court's decision? According to Article 19 of the Civil Code, every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. The abuse of rights rule established in Article 19 of the Civil Code requires every person to act with justice, to give everyone his due, and to observe honesty and good faith. When a right is exercised in a manner which discards these norms, resulting in damage to another, a legal wrong is committed for which the actor can be held accountable. A right is a power, privilege, or immunity guaranteed under a constitution, statute, or decisional law, or recognized as a result of long usage, constitutive of a legally enforceable claim of one person against another. Petitioner might verily be the owner of the land, with the right to enjoy, and to exclude any person from the enjoyment and disposal thereof. But the exercise of these rights is not without limitations. This is Suzette Bacanan. Thank you for watching.
Hi everyone, I am Eileen and I will be discussing the doctrine of the last clear chance.
It is also known as the doctrine of discovered peril, humanitarian doctrine, doctrine of intervening negligence, and the known danger rule. Under this doctrine, a person who has the last clear chance or opportunity of avoiding an accident, notwithstanding the negligent acts of his opponent or the negligence of a third person, which is imputed to his opponent, is considered in law solely responsible for the consequences of the accident. The doctrine presupposes a perilous situation created or existing through the negligence of both parties, but assumes and makes it a condition of the application of the doctrine that there was a time after the negligence occurred when defendant could have and the injured person could not have averted the accident. The theory on which recovery is permitted, notwithstanding the negligence of plaintiff in exposing himself to injury, is that such negligence does not, in a legal sense, contribute to the injury since it is a remote cause. It goes without saying that the plaintiff himself was not free from fault, for he was guilty of antecedent negligence in planting himself in the wrong side of the road. But where the defendant was also negligent, the problem always is to discover which agent is immediately and directly responsible. It will be noted that the negligent acts of the two parties were not contemporaneous, since the negligence of the defendant succeeded the negligence of the plaintiff by an appreciable interval. Under these circumstances, the law is that a person who has the last clear chance to avoid impending harm and fails to do so is chargeable with the consequences, without reference to the prior negligence of the other party. The law is that the person who has the last fair chance to avoid the impending harm and fails to do so is chargeable with the consequences. Last clear chance is a doctrine in law of torts which states that the contributory negligence of the party injured will not defeat the claim for damages if it is shown that the defendant might, by the exercise of reasonable care and prudence, have avoided the consequences of the negligence of the injured party. In such cases, the person who had the last clear chance to avoid the mishap is considered in law solely responsible for the consequences thereof. The doctrine of last clear chance, in essence, is to effect that where both parties are negligent, but the negligent act of one is appreciably later in time than that of the other, or when it is impossible to determine whose fault or negligence should be attributed to the accident, the one who had the last clear opportunity to avoid the impending harm and failed to do so is chargeable with the consequences thereof. Stated differently, the rule would also mean that an antecedent negligence of a person does not preclude the recovery of damages for the supervening negligence of or bar a defense against liability sought by another if the latter, who had the last fair chance, could have avoided the impending harm by the exercise of due diligence. In the case of Pantranco North Express Incorporated versus Baisa et al., GR number 79050-51, November 14, 1989. The facts of the case. The family of Baisa, together with the spouses Aiko, with their son and 7 other persons, were aboard a passenger jeepney on their way to a picnic at Malalam River to celebrate the 5th anniversary of spouses Baisa. David Aiko, owner of the jeepney, was driving. Upon taking the highway, the jeepney turned right and proceeded to Malalam River at a speed of about 20 km per hour, and a speedy Pantranco bus from Apare on its regular route to Manila encroached on the jeepney's lane while negotiating a curve and collided with it. As a result, David Aiko, spouses Baisa and their children died while the rest were injured. After the accident, the driver of the Pantranco bus, Ambrosio Ramirez, boarded a car and has remained in hiding. All victims settled the case under the no-fault insurance coverage of Pantranco. Maricar Baisa, through her guardian and Faye Aiko, filed a separate action for damages arising from quasi-delict against Pantranco. The latter invoked the defense of due diligence in the selection and supervision of its driver, Ramirez. The issue of the case: whether or not the doctrine of the last clear chance is applicable as to the jeepney driver. The court ruled that no, the doctrine applies only in situation where the plaintiff was guilty of prior or antecedent negligence, but the defendant, who has the last fair chance to avoid the impending harm and failed to do so, is made liable all the consequences of the accident, notwithstanding the prior negligence of the plaintiff. The subsequent negligence of the defendant in failing to exercise ordinary care to avoid injury to plaintiff becomes the immediate or the proximate cause of the accident, which intervenes between the accident and the more remote negligence of the plaintiff, thus making the defendant liable to the plaintiff. Generally, the last clear chance doctrine is invoked for the purpose of making a defendant liable to a plaintiff who was guilty of prior antecedent negligence, although it may be raised as a defense to defeat claim for damages. One bar question is about the collapse of structures. It also involves the last clear chance. So, Mr. and Mrs. R owned a burned out building, the firewall of which collapsed and destroyed the shop occupied by family of Mr. and Mrs. S, which resulted in injuries to said couple and the death of their daughter. So Mr. and Mrs. S had been warned by Mr. and Mrs. R to vacate the shop in view of its proximity to the weakened wall, but the former failed to do so. Mr. and Mrs. S filed against Mr. and Mrs. R an action for recovery of damages the former suffered as a result for the collapse of the firewall. In defense, Mr. and Mrs. R rely on the doctrine of the last clear chance, alleging that Mr. and Mrs. S had the last clear chance to avoid the accident if only they heeded the former's warning to vacate the shop, and therefore Mr. and Mrs. R prior negligence should be disregarded. If you were the judge, how would you decide the case? State your reasons. So the answer is, I would decide in favor of Mr. and Mrs. S. The proprietor of a building or structure is responsible for the damages resulting from its total or partial collapse, if it should be due to the lack of the necessary repairs, as provided in Article 2190 of the Civil Code. As regards the defense of the last clear chance, the same is not tenable because according to the Supreme Court in one case, and held in DeRoy versus Court of Appeals, the doctrine of the last clear chance is not applicable to instances covered by 2190 of the Civil Code. So further, also in Phoenix Construction Incorporated versus IAC, the Supreme Court held that the role of the common law, the last clear chance doctrine, in relation to Article 217 of the Civil Code is merely to mitigate damages within the context of contributory negligence.
That's all. Thank you for listening. Bye!